The next bill on the calendar for the day is House File 197. The clerk will report the bill.
House File number 197, number 3 on the calendar for the day, a resolution memorializing Congress to resolve that the requirements have been met to ratify the ERA, the first engrossment.
I recognize the author of the bill, the member from Hennepin, Representative Bonner, to explain House File 197.
Thank you, Mr. Speaker. Thank you, members. House File 197 proposes a federal resolution to Congress to acknowledge that the requirements have been met to ratify the ERA as the 28th Amendment to the U.S. Constitution. The amendment itself is quite simple and really quite elegant. It states equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. The federal resolution acknowledges that the conditions of Article 5 of the U.S. Constitution have been satisfied. Specifically, Article 5 provides two basic requirements. First, it must be ratified by a 2/3 majority of Congress. That was accomplished in 1972. Second, it must be ratified by 3/4 of the states. As of today, 38 of 50 states have ratified the ERA. The law states it shall take effect 2 years from final ratification. That occurred on January 27th, 2 years ago. We are already 1 year past. That date having passed, we ask Congress to act in accordance with the law and acknowledge the ERA as the 28th Amendment to the U.S. Constitution. This bill consistently has wide bipartisan votes among voters. You will be getting a handout with some information. I have actually several polls, but I wanted to just give you one for today. But what it shows, members, is that we see that voters overwhelmingly believe not only that equality should be the law of the land, but that it's time to make it happen. And with that, members, I urge you to vote green on the bill.
There are no amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File number 197.
Third reading. Discussion of House File 197. I recognize the member from Olmsted, Representative Quam.
Thank you, Mr. Speaker. Members, I don't think former Justice Ruth Bader Ginsburg was incompetent, and she has public statements about the expiration. So I just think you need to do the research and see what former Supreme Court Justice Ruth Bader Ginsburg said on this topic.
Discussion of House File 197. I recognize the member from Chisago, Representative New Brindley.
Thank you, Mr. Speaker. I'm sitting over here chuckling a little bit because I think that only Minnesota Democrats can take a widely bipartisan issue and turn it into something completely partisan, unworkable, and frankly, downright silly. It's incredibly frustrating. But I would like to address a couple of the things, frankly, Representative Quam just mentioned. Representative Quam, good news, I've got some quotes from Ruth Bader Ginsburg to address this. But you know, it's interesting. What should just be a really simple resolution? We support the U.S. Equal Rights Amendment. That would be a really simple resolution, and I suspect most of us would vote for it. But instead, this resolution goes on for 2.5 pages and throws in all kinds of silliness and absurdities. And one, it has to start, they actually have to say this because frankly, it's not true. Whereas, well, actually, I should say, we're mincing words. Whereas no time limit exists within the text of the proposed amendment that was ratified. Okay, Congress literally put a time limit on it. They extended the time limit once, but the time limit was June 30th, 1982. Congress put that time limit on it. We didn't. In fact, Minnesota ratified it. But Congress put a time limit on it. And that time limit was 40 years past by the time the final state ratified. The other thing that is kind of cute in the language of this resolution, whereas, I like this one, they have to try to justify again, whereas in 1868, the 14th Amendment was added to the Constitution despite 2 states purporting to rescind the ratification. They of course, had to add that because 5 states have rescinded. And just on these 2 issues particularly, this is what Supreme Court Justice Ruth Bader Ginsburg had to say. She said, I would like to see a new beginning. I'd like it to start over. There's too much controversy, she said. She said, if you count a latecomer on the plus side, how can you disregard states that said, we've changed our minds? This is from Ruth Bader Ginsburg. Ruth Bader Ginsburg, many times over, said that the congressionally imposed deadline was problematic, and that actually we don't have the authority to just override that, and the new Congress doesn't have the authority to just override that, and by her own words, the Supreme Court would even not have the authority to override that that congressionally imposed deadline. So, I mean, it makes me giggle a little bit that the Democrats actually put this stuff into the resolution, knowing that it's problematic, and even probably one of the greatest advocates for women that has ever walked this earth agrees with us on this, that it is problematic. And you know, the other thing, obviously, that is really problematic, not to mention, it's just no longer about women. This is no longer about women. And I'll tell you what, I spend as much time as probably anybody in this chamber fighting for women, but that's not what this is about anymore. This is a really easy no vote. I mean, again, this particular resolution is just silly. So, I don't know, vote how you want. It's a resolution. Nobody has to vote on a resolution at all. I think somebody said that, I mean, this has as much meaning as wishing Biden happy birthday or whatever. I mean, it's pretty meaningless, but this resolution is partisan, it's not really workable, and it's downright silly.
Further discussion of House File 197. I recognize the author of the bill, the member from Hennepin, Representative Bonner.
Thank you, Mr. Speaker. I just want to address very briefly, before my closing remarks, that when we talk to the courts, the highest law of the land, the final arbiter, is the United States Constitution itself. And anyone who's read Article 5 will know there are 2 things that were just discussed here that are glaringly missing. One, there is no provision, I mean none, that allows for an expiration of any amendment. And in fact, the 27th Amendment was ratified 202 years and 7 months after its introduction. Now, surely, if we can have a amendment that can go to almost 203 years, I think we can give women's rights a few years to make it happen. And I think that's justified. I also want to talk about recession. It is very clear that there is no mechanism under Article 5 for recession either, to be quite frank. And in fact, if we look at court precedent, we would find that there is absolutely no precedent for that in the Constitution. And in fact, the 14th Amendment, which is, by the way, part of the U.S. Constitution right now, today, New Jersey and Ohio attempted to withdraw their support. This attempt, however, was unsuccessful. Specifically, it was noted that Article 5 of the Constitution speaks only to the state's power to ratify the amendment, but not to the power to rescind a ratification. All precedents concerning state recessions of ratifications indicate that such actions are not valid, and that the constitutional amendment process, as described in Article 5, allows only for ratification. For example, the official tally of ratifying states for the 14th Amendment in 1868 by both the Secretary of State and Congress includes New Jersey and Ohio, states which had passed a resolution to rescind their ratification. It also includes in the tally where North Carolina and South Carolina, states which originally rejected and then later ratified the amendment. In the course of promulgating the 14th Amendment, therefore, Congress determined that both attempted withdrawal of the ratifications and the previous rejections prior to ratification had no legal validity. Let me read that again. Congress determined that both attempted withdrawals of the ratification and previous rejections prior to the ratification had no legal validity. And in fact, to be clear, the 14th Amendment is currently in the Constitution. It should also be worth noting here today that of all 27 of the amendments to the United States Constitution currently in force, not one ever had an expiration placed on it. The only one that had an expiration placed on it were women's rights. I want that to sink in for folks, because it is here that we have to understand the very, very core of this issue is that expiration dates we already know are movable. We already know that because Congress has already done it. They've already established that precedent. It's also worth noting that in terms of legal precedent, that this was intentionally not put into the body of the amendment. It was put in the preamble. The preamble gave Congress a great deal of flexibility. But it also is interesting to note that from a legal perspective, that when it goes into the preamble, first of all, that there is no legal precedent that establishes the preamble as a source of law, and therefore, it is unenforceable by many constitutional scholars who have looked into this issue. Many go so far as to suggest that Congress lacks the authority to impose deadlines on ratification, as no such allowance is made under Article 5 of the U.S. Constitution. Further, after the Nevada ratification in 2017, a white paper was produced for Congress to determine if the deadline excluded ERA from inclusion in the U.S. Constitution. It concluded that this was not valid and allowed for the ratifications. But that said, members, now that we've cleared up a few of those distinctions, I wanted to start with just grounding us here today and thanking everyone here today for the fact that we are here to wish happy birthday to the state of Minnesota. That there are many incredible things happening in this chamber today. And I'm proud to stand in this chamber today. It is the most diverse chamber in our history. We have more women, We have more members of every race, religion, creed, and ethnicity in this body. Today, we have an opportunity to come together and to boldly declare that equality under the highest law of the land, the U.S. Constitution, should be reality for every Minnesotan and for every citizen. Sadly, we know this is not the case. We have seen in recent years erosions of our rights and freedoms. The promise of America was built on the ideal of freedom, promised to all, but realized by a select few. Supreme Court Ruth Bader Ginsburg famously quoted Sarah Moore Grimke, a 19th century abolitionist and women's rights activist. She said before the court, "I ask no favor for my sex. All I ask of our brethren is that they take their feet off our necks." Members, women are tired. Women are weary. They are tired of waiting their turn for the full promise of rights and freedoms, for basic equality under the law. American women have fought for hundreds of years, have fought and scraped for every small privilege. The right not to be the property of another, the right to inherit, the right to vote, the right to financial freedom, to take out a loan, a credit card, a mortgage, without their husband's permission. We fight for justice in this very chamber every day. For the laws to protect us. We fight for the laws to protect us from violence, to bring swift justice, not justice delayed or justice that never comes. We fought for the right to die for our country, to be healers and faith leaders, to be leaders in our community, leaders in the halls of government. We stand today on the shoulders of giants, generations of women who came before us, women who knew the sting of oppression deep, deep in their bones, who felt injustice at its core. Women who planted trees in whose shade they would never see. They planted seeds for generations yet to come. With steadfast determination that future generations would not have less rights or freedoms than they toiled to win. But I find hope in this resolution today. It brings with it justice. It brings with it an opportunity for us to lift up one another, men and women. For if one of us is not equal in the eyes of the law, none of us are truly free. The time has passed to ponder and to pontificate. The time to act is now. With this federal resolution, we have the power to restore the dream of freedom and of equality under the law, to make it a shared destiny for all. In closing, the words of Lyndon B. Johnson, "We have talked long enough in this country about equal rights, 100 years or more. It is time to write the next chapter, and time to write it in the books of law." And with that, members, I urge you to vote green.
Further discussion of House File 197. I recognize the member from Freeborn, Representative Bennett.
Thank you, Mr. Speaker. Members, I don't need a piece of paper to tell me that I have equal rights. Women already have equal rights in this state. Women already have equal rights in this nation. I urge you to vote no. I'm sorry, but I think this is a silly resolution. It's not needed. We have equal rights. I stand on that. I don't need a piece of paper to tell me that. Thank you.
Further discussion of House File 197. I recognize the member from Douglas, Representative Franson.
Thank you, Mr. Speaker. Would Representative Bonner yield to a question?
Representative Bonner, she will not yield. Representative Franson.
Okay, well, Mr. Speaker here, I am trying to decide if I want to vote yes for the bill or for the resolution or no for the resolution. And Representative Bonner is the author of the resolution, so therefore I am curious to see why Representative Bonner would not want to answer a question that's related to the resolution she would like passed, and I'm assuming with bipartisan support. So I will ask once again, would Representative Bonner yield to a question?
Representative Bonner, will you yield to a question? She will yield. Representative Franson.
Thank you, Representative Bonner. So as I stated, I assume that you would like bipartisan support on this resolution here. So could you describe for the body what your definition of a woman is? Thank you.
I recognize the member from Hennepin, Representative Bonner.
Thank you for that question. I will tell you that the definitions around sex and gender have already been determined by the Supreme Court. They were determined under the Bostock decision, as well as I believe it was Zelenda and Stevens. And they used as the foundation for that the Civil Rights Act of 1964 and determined that those two terms are interchangeable and can have a more broad definition, particularly when it comes to discrimination.
Representative Franson.
All right, thank you, Mr. Speaker and members. I think you have it. Representative Bonner cannot describe to the body what a woman is, and therefore my vote will be no. Thank you.
Further discussion of House File 197. I recognize the member from Stearns, the Minority Leader, Representative Damath.
Thank you, Mr. Speaker. And members, there's been a little bit of discussion, as we've heard both from the Democrats and the description of this resolution, and you've heard from the Republicans and some thoughts and opinions on that. One thing that I do agree with, as the resolution author had mentioned, I'm not asking anyone to yield, but as she had mentioned in her description, that women have fought over years. And there is a historic number of women serving in this chamber. Also, there was a whole description there. But I have to tell you that women have fought to be in this chamber. Men have fought to be in this chamber. And I don't think we need the words of a resolution to define or describe what equal rights are. I am proud to stand here in this chamber, and it doesn't take the words on a page to let me know that the battles that were fought over time by my grandmother, my mother, my grandfather, my father, I don't need any description like that to let me know that I have equal rights. I am here to serve my constituents. I am here to serve the state of Minnesota. I believe that is all our intent of all of us sitting here. I will be voting no on this, and I fully know that we have done everything possible to get us into this chamber right now and serve this state in the best way possible. Thank you, Mr. Speaker.
Further discussion of House File 197. I recognize the author. I recognize the member from Hennepin, Representative Katiza Wattoon.
Thank you, Mr. Speaker. And I rise to support this resolution today. Now there's been some discussion about the definition of men, definition of women. Women know what it's like to be other than, because we were not included in our Constitution originally. And that's why we need to pass this amendment. There are other people in this body who are descendants of slaves, and black people did not. They were not included in our original Constitution, and we passed an amendment saying that they have those rights. This is about equal rights for everyone, period. And if you vote red, you're voting against that.
Further discussion of House File 197. I recognize the author of the bill, the member from Hennepin, Representative Bonner.
Thank you, members, for the discussion. I just want to point out that I appreciate what folks have said here today. And perhaps some folks in this room do feel equal today. But here's the reality. Based on the law, you are not. Currently, women are the only unprotected class in the United States Constitution. That is a fact. And that can be looked up quite easily. You don't need to take my word for it. You can read the document for yourself. We've had numerous legal court cases that have gone forward that have challenged this information. But the reality is, it's been made quite plain that women didn't have that ability. We do not have equal rights provided under the Constitution. Why does that matter? Why does it matter if we're not equal in the eyes of the law? Well, it matters because we have this patchwork of elaborate laws that we put together to protect ourselves from violence, for voting, to inherit. By the way, did you know that the first rights that we were granted on being able to own property, they weren't magnanimous. That wasn't to actually give rights to women. It was designed as a way to shelter assets, not to give women more rights. I think it's worth bearing note to the fact that at every turn, for hundreds of years, women have asked to be included. We're the United States of America. We've been given this promise of rights, freedoms, life, liberty, the pursuit of happiness, and yet there is nowhere in that document in which women are represented. Not one space. It should be noted, too, that even within the bounds of our own state, we have a Constitution, too. Our head Supreme Court Justice is Laura Gilday. She upholds the contents of that document every day, even though she is not represented among its pages. Why does it matter if women are equal? I don't know about you, but I don't like the laws on the books. We are lawmakers. We understand the importance of the law. I do not like the feeling that young women can roll the dice with the courts. And at best, they have a 50-50 shot at whether or not the law will be upheld. I don't know about you members, but I don't like the idea of my rights and freedoms having a 50% chance of actually being upheld. That's why it matters, people. That is why it matters. That's why it should matter to everyone on this floor. And we could dive into the definitions of intermediate scrutiny versus strict scrutiny and how that plays out. But anybody here who's ever placed a bet would know that I want to know that I have a better than 50% shot that someone's going to uphold the law. That the law is going to protect my rights and freedoms, the rights and freedoms of the next generation, my young nieces who are about to graduate, And Isabella, who sits with me on the floor every day on my desk. Isabella is 6 and she can't be here tonight because it's close to her bedtime. But when I think about equal rights and freedoms, I don't want to take your word for it. I don't want to take anyone's word for it. I want it in writing. And so should every woman in this room. Our rights are non-negotiable. Our freedoms are non-negotiable. The erosions we've seen of late do not give me great comfort. But you know what would give me great comfort? Seeing it in writing. In writing, in the U.S. Constitution, the highest law of the land. And with that, members, vote green.
The clerk will take the roll on House File 197.
Can we get Peter? I'm sorry. They're just such assholes. I was like, green, green, green. No, I didn't want you to have to lean over. Well, I don't want to. I'm sorry, I took your vote away.
I don't care. I really, literally don't care.
Okay, good.
Everyone's
Well,
like,
some
this
people
is the
do.
most important part of your job is pushing the button. If you think that's the most important part of my job, you don't understand how this place works.
Members, please vote.
Yes. The baby's been here the whole time. It's sweet.
Have all members who wish to vote voted?
Oh, yeah. I already squeezed.
The clerk will close the roll. There being 69 ayes and 51 nays, the bill is passed and its title agreed to.